questions having been with the appellate position are here, in attendance, shall be heard. Please be seated. All right, wow, we got a full house here. Okay, so I will do the usual spiel. We have almost 7 hours of argument time. It's 2 o'clock now by my quick math at 9 o'clock at night. I'm not so sure everybody wants to be here until 9 o'clock at night. So please ask for the time that you need to make your point. We've already read everything. So having said that, first case up, People versus Cornelia Epemge. 4 and 2 and 3. Fata versus Hesco Riverdale. Okay, 5 and 2 and 5. Got it. Lewis versus the City of New York.
Helen, 3 and 1, please.
3 and 1 and 4. Thank you. People versus Marquise M is submitted. Tor Central versus Thor 38.
Respondent.
You want to submit?
3 minutes.
3.
I'll say hold on.
Be careful what you wish for. Okay, 3 minutes. People versus Christopher Santiago.
Appellant requests 4 and 2.
Respondent requests 4.
You got 4, 2, and 3. Thank you. JT Majan versus Nissan North America.
Appellant requests 9 and 3.
Respondent Nissan North America and Philadelphia Indefinitely request 10. And I also would like to present my partner.
Which one? There are 2 people sitting. Okay. I got Nissan as one of the Nissan Philadelphia, and the second one is Georgetown. You represent Georgetown? See, I did my homework. I know what we got. Okay, so this is what we're going to. What did you ask for? I'm sorry, Counsel?
9 and 3, Your Honor.
All right, 6 and 3, 5 and 5. If we have more questions, we'll continue past the time I've allotted. Thank you. People versus Mamadou Coulibaly. I'm sorry if I messed that up.
Fine, Your Honor. Appellant requests 6 minutes and 2 for rebuttal.
All right, 5 and 3 and 5. Thank you. Wright versus the City of New York.
Appellant 5 and 2.
Respondent City of New York requests 3 minutes.
Okay. Do we have Sabrina Wright here? She was other listed as a respondent. Okay, so it's 5 and 2 and 3, correct? Thank you. Bradley versus NYU Langone.
Plaintiff responded, appellant, 5 and 1.
5 and 1, you said?
Yes.
NYU, right? You represent NYU? I do. Okay. 5 and 2. And the respondent?
Your Honor, respondent ASR will request 3.
Okay, so thank you. So that's 5 and 2 for the appellant NYU, 5 and 1 for the appellant plaintiff, and 5 for the respondent ASR, correct? All right, thank you. Okay, Talos Capital versus 257 Church Holdings.
Non-party appellant requests 7 and 3, please, Your Honor.
Respondent, Your Honor, requests 8.
I'm sorry?
Respondent requests 8, Your Honor.
8 minutes. I'll give you 7 and 3 and 6, and if we have more time, we'll go. Questions will continue. Thank you. Monash versus New York Institute of Technology.
Skipped one.
Okay. Okay, so we got 5 and 2. Hold on one second.
Skipped one.
That's why I got wing people on this side here. People versus Raymond Talavera. You are? Okay. You want to submit? Yes. Thank you. Okay, I got the Mensa versus New York Institute. We're giving them 5 and 2, right? That's what they asked for. People versus Angel Ufret. That's a submit. Heribovich versus United Cerebral Palsy. That's a submit. 5th and 55th versus Vistana Signature. Welcome aboard. Okay, 5 and 2 and 5, thank you. And the last case, Richardson versus Garley, that's a submit. Okay, folks, very good. First case up, People versus Cornelius, Epkembe, I'm sorry. Pronunciation is bad. Okay, counsel.
Good afternoon, Your Honors. Victoria Wu, Office of the Appellate Defender, on behalf of Cornelius Ikbembe. The sentence of 2 to 4 years of prison should be reduced in the interest of justice to 1.5 to 3 years of prison. The mitigating circumstances in this case, including Ms. Ikbembe's history of trauma, mental health and substance use challenges.
Excuse me for interrupting you, but this was a court offer that was made to the defendant? The court made the offer to the defendant?
I believe that the prosecution made the offer here.
But this happened after they had received a pre-pleading memorandum, which basically spoke about all of these mitigating circumstances and all of the things that this defendant had gone through throughout his life before that point.
Yes, that's correct. This was the result of a negotiated plea, but this court has the power and the responsibility to determine whether a sentence imposed was unnecessarily long.
But that's something that the court had already considered when it went along with the plea offer.
Yes, the court below considered the mitigation in this record, but again, this court has the independent authority to determine whether a sentence should be reduced in the interest of justice.
And counsel, the court considered it because your client was facing 7 years state incarceration, right?
Yes, yes, exactly. But
And the offer was significantly less than what your client faced, correct?
that is correct. But again, the guiding principle here is whether the sentence that was imposed is the minimum.
Well, you also missed the point that the statute here provides for an enhancement because he was charged for attacking someone who was 68 years old, and the statute says if you're 65 or older, there's an enhanced type of situation there, right? And this is the case here. The gentleman was 68 years old, standing on the corner, and he gets whacked.
Your Honor, and I would note that the indictment in this case also charged the misdemeanor count of assault 3. So in the prosecution's own view, that was an appropriate reflection of the incident here. The plea was down to an attempted assault 2, which was not the actual top count of assault 2. And Ms. Ikbembe has accepted responsibility for her actions in this case. She expressed her apology both at sentencing and in her interview with probation prior to sentencing. There's no doubt here that she has done that. In addition, her history—
You have a valid waiver here?
The appeal waiver is not valid for several reasons, Your Honor. First, the court below did not explain that the right to appeal is separate and distinct from trial rights because it is not automatically forfeited upon a guilty plea. In fact, the court conflated the right to appeal with the trial rights by telling Ms. Ikbembe, quote, had you chosen to go to trial and you're convicted, ordinarily you would contest on appeal any mistakes. So that sentence incorrectly gave the impression that Ms. Ikbembe was actually giving up her appellate rights in part because she was pleading guilty. In addition, the court—
Now, counsel, if I may, your client has a significant criminal history, right? 22 misdemeanor convictions in this state and also a number of convictions in New Jersey and a bench warrant history, correct?
That's correct. That largely reflects her struggles with mental health and substance use. You'll see that the prior convictions were all primarily drug and theft related, and again, that reflects my client's prior struggles with depression, bipolar disorder, her addiction with alcohol, cocaine, and other controlled substances.
Is he a violent predicate felon?
Uh,
Is he a violent predicate felon?
she has a prior, yes.
So all that sort of reflects that she received a good deal. at the
Well,
trial court.
Your Honor, I still think that a modest reduction in the sentence here from 2 to 4 to 1.5 to 3 is still appropriate in light of the array of mitigation here that we have in the record.
All right, you have rebuttal time. Thank you.
Thank you.
Good afternoon, and may it please the court, Catherine Murata for the people. Defendant's sentence was fair and appropriate and should not be disturbed on appeal. First, all the mitigating factors that defendant referenced.
How about the valid, challenging the waiver, saying that it's not valid? What's your response to that?
Your Honor, the waiver, defendant validly waived her right to appeal here. Justice Menon properly separated the trial rights from the appellate rights that defendant was waiving.
Didn't Justice Menon, by saying that had you chosen to go to trial, limited the appellate rights to the event had defendant gone to trial, given the wrong impression?
Your Honor, there was some imprecision in that statement, but any ambiguity was cured by the detailed written waiver, which defendant thoroughly discussed with her counsel and confirmed that she read the written waiver and that she had no questions about it. So any imprecision in that statement was cured by the written waiver.
Does the record reflect that that was done in court? Was there an acknowledgement that going over the waiver was done in court?
Yes, after the judge discussed the trial rights, she moved to discuss the appellate rights, the waiver of appeal. She paused the proceedings so that defendant could discuss the waiver of appeal with her counsel. Counsel acknowledged that she read the waiver of appeal and discussed the appeal waiver with her counsel and that she had no questions about it. As to the excessive sentence point, all the mitigating factors were already discussed at the plea and sentencing proceeding, and Justice Menon was aware of them when she fashioned the sentence. Also, this crime here was quite serious. A defendant violently attacked a 68-year-old deaf and mute stranger, throwing him off his bike and punching him as he fell. And just to note, a defendant also has an extensive criminal history. She has 22 misdemeanor convictions in New York, including third-degree assault and second-degree menacing, but she also has 2 felony convictions, both violent felonies, one for second-degree robbery and one for attempted second-degree robbery.
Counsel, if I may, with respect to this instant offense, the instant offense was committed while the defendant was on post-release supervision, right?
That's correct.
Okay.
Sorry.
No. And for the present sentence, there is no post-release supervision. Am I correct about that?
That's correct. There was no mandated post-release supervision under this conviction. But yes, defendant was serving her term of post-release supervision while she committed the instant offense.
And among the 22 misdemeanor convictions in this state, 2 of those are for menacing and third-degree assault.
Correct. Yes.
And is it right that the defendant was a violent predicate felon?
Defendant is a violent predicate felon, yes. She has the second-degree robbery and the attempted second-degree robbery, both which are violent felonies. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Just briefly, Your Honors, regarding the appeal waiver, respondent has invoked the written waiver form, but the court in this case did not orally confirm with Ms. Ibembe that she had actually understood the form. That is essential in order to render a written waiver form valid. In addition, this court has recognized that a written waiver form cannot cure an affirmative and misleading statement made by the court during the oral colloquy. Here, as you, Honors, have pointed out, the court misled Ms. Ipembe to believe that she was waiving part of her appellate rights in part because she was pleading guilty rather than going to trial. So for that reason, the appeal waiver is not enforceable, and this court may properly consider the merits of the excessive sentence claim. Respondent has also emphasized that Ms. Ipembe was on post-release supervision when the incident happened in this case. That is true, but I think that goes to show that the preceding 7-year prison sentence that she had served was not sufficient to provide the mental health and the substance treatment that she needed in order to lead a stable life. And that consideration certainly warrants a reduction in the sentence. And related to that, Ms. Impebe is a transgender person, as everyone here agrees, and for her, a reduction in the sentence is meaningful because it will reduce the amount of time in which she's in an environment in which she is vulnerable to abuse and mistreatment. And so for all the reasons I've laid out, I would ask this court to reduce her sentence from 2 to 4 to 1.5 to 3 years of prison. Thank you.
Thank you.
Fata versus Heskills Riverdale.
Good afternoon, Your Honors. Catherine Herr Solomon on behalf of the defendant appellant, Heskills Riverdale LLC. The trial court's order striking of the defendant's...
So how do you explain in this situation where the superintendent on his own, whatever motive he has, he views the videotape. Not only does he view it, he has his wife view it, and then he gives the deposition testimony and says, you know what, he didn't trip on anything, he just fell on his own. That's pretty, normally... And how you teed it up to move to dismiss when you had summary judgment. I think this was a summary judgment motion. Oh no, this was the defendant's motion to strike. Your answer, your response, or at least you were challenging the notion not of notice or cause and create, but you actually attacked the plaintiff's, memory, cognitive ability, which goes to the heart of whatever the super saw in the video. So how is that not highly prejudicial that it's gone now?
Well, I think that this court's recent decision in Legacy versus Nominelli is directly on point because in that case, the defendant deleted an email account after he was directed...
No, but that case is distinguishable. That's a case where the plaintiff, we said that the plaintiff is still able to prove or at least set forth their case.
Right.
This is not that situation. The plaintiff's already able to set forth the case. It's now you're essentially... when you commence a lawsuit, you'd like to think that you have a 50-50 chance of prevailing, right? In this case here, there's no 50-50. It's like if the super gets up on the stand and testify, I saw the video, he tripped and fell. And then you bring in the records and say that, the plaintiff has memory, cognitive issues and all that. How's that scale going to tip?
So that's relative to the sanction. The sanction could be that no one can discuss the contents of that video, which is exactly what this court held in New York City Housing Authority versus ProQuest and Strong versus City of New York. That's the appropriate sanction. The plaintiff in this case has enough evidence to put forth before a jury to attempt to prove his case.
What evidence does he have? I mean, you're already attacking his lack of memory, which he claims is as a result of this injury. So that's hard to overcome. There were no witnesses. The best evidence here was the video, and it was destroyed.
Especially in light of the fact that medical records were introduced indicating that there is a history of him tripping and falling.
The plaintiff testified at his
And I'll add
deposition.
to that. Here's the other problem with that, preventing him from testifying. We have an EBT now. We have a deposition. I know attorneys are creative. Somehow, some way, they're going to get that in front of a jury somehow, ring that bell. So that's also a problem, right?
I mean, there's enough...
I've been at the trial court. I know how these guys, some of the lawyers work. When you say you can't do it, next thing you know, the bell gets rung.
Well, that would be a grounds for a mistrial, I would imagine, if the judge says you cannot talk about this videotape. But the other important thing that is being missed is that plaintiff was able to testify at his deposition that he tripped and fell over the height differential created by the metal plate cover.
Right.
And I'm glad you brought that up, because also, we don't have the metal cover. For whatever reason, the super disposed of it. Waited a year, disposed of it, when he knew that the case was pending. So we don't have the video, we don't have the metal plate cover.
Right, but
no memory.
But the metal plate cover is not something that plaintiff is going to bring into court to prove his case. The plaintiff, in addition to his deposition...
That's up to plaintiff, right? And that's precisely the problem, that you've taken away that option for the plaintiff.
But there are photographs of the scene of the fall that accurately reflect the area at the time of the fall that plaintiff's counsel took 3 weeks after the fall. So in most trip and fall cases, there isn't a video, and plaintiffs come in with their own testimony. This is what I fell on, and here are the photos of the defective condition that I tripped over. And that is enough to prove a case.
So what is it that you propose as a limiting, as a charge to the jury
That, well,
in this case?
that they're either an adverse inference charge to say that there was a video and it's no longer available, and the jury can, infer that whatever was on the video was not helpful to the defense, or an instruction to counsel that there is to be no discussion of the video, and it's as if there was no video and it's an equal playing field at that point.
I have a hard time saying that it's equal when it's established that the plaintiff has memory issues, particularly because of this injury. It can never be equal at this point, unless the defense counsel is going to commit to not attacking his memory.
But he was able to testify at his deposition that he recalled the accident and what he tripped over.
That's it. That's it. But then there's memory issues after that.
And what about the issue with regard to his medical records, which indicate that he was prone to tripping and falling, that he was unstable on his feet, which were records introduced by your client?
Whether the video was available or not, that would be relevant evidence to be admitted at trial.
True, except that the video would have definitively shown one way or the other. The video would have spoken for itself. You don't have to take the plaintiff's word for it. You don't have to take the super's word for it, right? The jury would have been able to see the video and determine either he slipped because he has an imbalance issue, or he slipped on the straight, or something else. But we don't have that.
Right, but the sanction of striking the answer is extreme, especially in this case when the plaintiff does have evidence to present to a jury, and the adverse inference charge would address that concern.
How often do you find the same individual destroying two critical pieces of evidence in the same case? One, before there's an action pending, but he looks at it and he says, this probably causes a problem for us. And then the second one, a year after there's already an action pending.
There's no evidence that the super was conspiring to get rid of evidence. I mean, I think a fair reading of his deposition testimony establishes that
Let's add to that. Let's add to that, because the super saw the plaintiff bleeding from the head, needed medical assistance, called later to find out how the plaintiff is doing.
So the plaintiff he helped the plaintiff up. Yes, he had a small area of bloody.
The plaintiff called for help. He called for help.
Well, because
it came minutes later.
Right, but he got up and then got into his car and drove away. That's what the super saw. And the super called him and asked him, "How are you doing?" "I'm fine." The super had no idea that he sought medical attention until after the video had been already automatically
You're telling
overwritten.
me that a super that runs to someone's aid that cannot get up, person's on the floor, is elderly, has an injury, right? Whether you consider it serious or not, that super didn't have the wherewithal to think liability?
And showed it to his wife as well. Showed the video to his wife.
He showed the video to his wife because they were discussing this is what happened today. Look what happened to Mr. Fada. I mean, I think that a fair reading of his deposition testimony is that he was perhaps negligent and not, didn't realize. He said, "I didn't realize it was important, so I didn't." Wow. He falls often.
Okay.
He
All right,
got
you
up
have
and drove
rebuttal time.
away.
Thank you. You've gone way over. Thank you.
Good afternoon, Your Honor. It's Michael Heck for the respondent.
Why isn't an adverse inference enough?
Basically, we offered evidence that Mr. Fada on day one, he couldn't recite what happened when he went to the doctor. And Your Honor, with all due respect, they did cross-move for summary judgment. And
Oh, I only have the.
they did. And in those,
Oh, they're not appealing that.
they're not appealing that, Your Honor. And I'm going to tell you exactly, if I may, what they said. Plaintiff cannot offer any evidence supporting its allegations that the metal plate drain cover in the garage floor was the actual approximate cause of the fall. So if they are saying their facts that he can't even testify because of his brain injury and memory problems.
Well, you know, if you heard our questions here, it's more like a level playing field. So in addition to the adverse inference charge, don't you, I mean, one of the cases that we read today suggests even going further, not only an adverse inference charge, but also precluding the super from testifying at all about what he saw in the video, precluding anything about what he did with respect to the metal crate, except the adverse inference that a video has been destroyed and a crate and the metal cover has been disposed of. You know, you get that kind of situation. As my colleague said, you have medical records now. They have medical records, which, you know, if you put your condition at issue, the medical records can come in. So why isn't that palatable in terms of
Your Honor, Mr. Fata has been fatally compromised because of the destruction of this video. He, unquestionably, we in our motion papers said it. We said he had no recollection of the incident of what happened on day one. He did, as time came on, if you read the papers, that in the records, things started coming back later in the day. He told the ambulance that he stumbled. And
so then you can at least tailor the super's testimony that he approached the individual, saw him on the ground bleeding from the head, so that at least at a minimum is something that you would need, because you already said that your client's at a situation where he's not, I mean, there's a lot going on, but at least the testimony of the super is clear that he did find your client on the ground bleeding from the head,
but,
right?
Your Honor,
and that's all he can testify to.
If there's testimony on liability, we know that they're going to go after his memory. We know that, and he's been fatally compromised.
But as my colleague said, even if you didn't have the video situation, if there were no video, there were no cover issue, the medical records, as far as I believe, I'm not too far removed from trial, that's fair game. Once you put a condition at issue, right?
Your Honor, I understand what you're saying. Medical records certainly come into play in a personal injury case. But Your Honor, they have already presented facts that they said he cannot make out a prima facie case. So now they're coming in to say, well, let him testify and we just want an adverse inference. It is inappropriate for them to have it both ways factually. They cannot do that. They can argue differences of the law, but that's not what they're doing. They're saying, Your Honor, that when it suited them in their summary judgment motion to say, well, Mr. Fata should get thrown out of court because he doesn't have the capability.
Well, we're beyond that. The motion was denied, so now we're going, right?
Your Honor, without that capability to testify, which they have relied on, how can he make out a prima facie case?
You mean, when you're saying he can't testify, he will not be getting, I mean, your client will.
They have said his testimony would be
get what he said. He's going to get up and testify as to what happened.
He's going to try.
He's going to try, right?
If Your Honors reverse this, which I request you don't, it's unfair. It's blatantly unfair what happened to this.
But isn't his testimony already preserved in his deposition as to how it is that he sustained whatever injuries he sustained?
He did testify as to what happened.
So?
And what he recalled, yes, Your Honor. Mm-hmm. But what they did was they said that testimony should not be accepted because it's speculative. So for them to be allowed to proceed to trial, it's not fair. It's just simply not fair, and we're here to be fair, in all honesty. And what they did to this...
So in essence, their argument is that his testimony should not be relied upon. It's unreliable because he has memory issues. And then the best evidence that would have supported or contradicted his case, they destroyed.
The only evidence, Your Honor, the only evidence. The case law says when you are fatally compromised or prejudicially bereft due to spoliation, the answer
But the other evidence is the medical records with respect to his ability to remember.
Okay, Your Honor, if somebody had issues with stumbling or whatever, why does that mean that they stumbled or they lost their balance on this occasion? This occasion, he tripped. That's what he said. And they said, that's not good enough, it is speculative.
And that's for a trier of fact to figure out. That's exactly what a trial's for.
But, Your Honor, they're saying that he can't even get that far.
I have a colleague here, unless I'm mistaken, that his testimony is preserved by an EBT. So if whatever he can't remember on the stand, he's going to be able to be given the EBT to
I
testify
don't
to.
know if I'm misunderstanding.
Maybe I'm missing something.
I apologize, but what I'm saying, Your Honor, is that
That's
testimony.
what happens when I don't have an extra cup of coffee. So yeah.
I hear you. That testimony in that EBT has been characterized already to the Supreme Court below as speculative and inadmissible.
That's when
the
they did the motion for summary judgment?
That was the basis for their summary.
And that was rejected. That was
was
denied.
rejected.
And they didn't take an appeal. So guess what? Now you go to trial. What are they going to point to something that the Supreme Court's already rejected? They can't bring that argument again because it's no longer an argument.
It's a factual allegation that they have made, and they're stuck with it. And their factual allegations.
Counsel, the way I look at it is they made that argument in their cross motion for summary judgment, okay? Supreme Court rejected it. The argument about how you can't make out your prima facie case. So for whatever reason, those arguments in my mind have been rejected. They've not appealed, which means now that's law of the case. So if they try to go and revisit that and push that argument again at trial, I think they're subject to collateral estoppel because that's already done. That's gone. How are you going to raise an argument that the court decided and they didn't take an appeal on?
I think that this court was left with one thing or the other. The spoliation, it was an all or nothing either way.
I only have in front of me their appeal. I have no appeal with respect to their cross motion, unless I'm missing something.
No, we haven't. We haven't appealed. We're the respondent, Your Honor.
Why would you appeal the cross motion? It was denied.
We won.
Yeah, you won. Exactly. So, okay, I got it.
I'm overstating my time. Your Honor,
we got
thank
it.
you very much. I hope I've answered your question. I would ask you to please affirm.
Okay, thank you.
The plaintiff testified clearly at his deposition that that's at page 112 to 113 of the record, that he tripped over the differential that was created by the metal crate and the metal cover and the ground. And that testimony, plaintiff is free to testify to that again at trial. And if he is unable to, then that deposition testimony can be used at trial. At this point, I just wanted to point out that the defense is now can't even obtain discovery on damages. So in order to level the playing field, it would be appropriate to issue a lesser sanction.
Why wouldn't you be entitled to damages discovery?
Because plaintiff
the liability issue that got resolved.
Plaintiff moved in the middle of discovery, before discovery was complete.
Yeah, but unless I'm reading the wrong decision, Supreme Court only they prevailed only on the issue of liability. Damages are still, discovery can go forward on damages, right?
I believe when your answer is struck, it's treated like a default judgment, and then you're precluded from discovery.
Liability only.
Only liability only, not damages, because you still got to go forward. I could be wrong, but I've seen those, and
in any event, I think that this extreme sanction of striking the answer was not appropriate under these circumstances, and a lesser.
Well, would you agree with my comment about how your issues that you put forward in your cross motion, which were rejected by Supreme Court and not appealed, those issues are not, they're gone. You can't even bring that up at trial.
Right, and
wait, when you say yes, are you telling us that you're not going to argue to the jury that he has memory issues? I doubt that.
I mean, if it's in the medical records,
right,
then I assume that argument will be made. But that argument would have been made if the videotape didn't exist.
That may be true, but if the videotape existed, it may not have as much teeth as it otherwise has.
Assuming that the videotape is...
And that's what we have to do, assume that is the very problem, because we don't have it.
That's leveling the playing field. Okay, thank you. I got it.
Thank you.
Lewis versus City of New York. Okay, counsel.
Good afternoon, Your Honors. I'm Joshua Annenberg, and I'm appellate counsel for the plaintiff appellant in this slip and fall action. The primary legal issue on our appeal is the lower court's error in granting summary judgment to the defendant city, where the defendant failed to sustain its evidentiary burden of proving lack of constructive notice of the dirty, muddy, tracked-in slush and snow in the school's main office.
Correct me if I'm wrong, but in the record here, the school was open up at 8 o'clock in the morning? Something around that time?
A little earlier than that, the testimony from the maintenance supervisor, who merely delegated everything,
Yeah.
didn't do it himself, was that the school employees arrive at 7:30 a.m., and everybody else, students or others.
So at 7:30, people are coming into the building
Correct.
already, right?
Other-
And the plaintiff here slipped and fell at 8:15?
At 8:15, that's correct.
45 minutes into the time the school opened,
Exactly.
he slipped and fall.
Exactly.
Is that enough time to
No, you see,
get notice?
what I'd like to do is if I could direct the court to the record at page 138. This is a principal issue in our argument, is that since this court's own case law holds that the burden is on the defendant to essentially disprove constructive notice, to prove there was no constructive notice, and that they must do so by specific evidence of the maintenance procedures at the time, and specifically also of when the last time in this instance would be the school's main office was cleaned or inspected, and that the condition did not exist at that time. Well, we've already discussed just now that the maintenance supervisor has no personal knowledge because all he did was delegate.
But he testified that this is what they do.
This is
all
what
the
they would do. This is their general custom and practice and procedure, which this court, as discussed in my brief, rejects as a basis for a defendant sustaining the burden on constructive notice, because there is...
With regards to the custom and procedure that he testified to, did he speak about the custom and procedure with regards to the inside of the school?
He did. It was generally the customer procedure would be, after everybody would arrive, they would go in and they would go floor by floor and they would inspect and
But that's after people arrive, right?
That's correct.
Was there any testimony about before? Specifically, what was the condition of the office before, let's say, 7:30?
There is absolutely no testimony from him as to what the condition was before 7:30, and that's very critical because under this court's case law, you have to have specific evidence of when exactly the main office was last inspected and what its condition was.
Now, on the day of this incident, the school had been closed due to snow, I believe, the day
That's correct, the day prior. That's correct. So what they did was they opened. Before opening, they cleaned the snow and the outside.
Didn't he point to notations in a logbook referencing what was done on that day in terms of having made the school ready to be open?
I'm sorry, I just didn't hear you, Honor.
He didn't point to notations in a logbook during his deposition regarding what was done on that day in terms of making the school ready for people to come in?
The only thing in the log, and this is quite critical, and if I point out at record page 138, is a two-line note, and it says as follows. For that day at issue 1518, custodian staff in to remove snow and ice for opening. X085 is the designation of the school. Ready to receive staff and students.
Does that mean that the office is basically has been inspected?
As I've argued in our brief, it means nothing as a matter of law pursuant to this court's own case law. It doesn't say when, it doesn't say where, it doesn't say how anything was cleaned or inspected, and it certainly doesn't go and specify with specific evidence to cleaning the main office at any given time prior to 8:15 a.m., and it doesn't give the condition of the floor at that period of time.
Can we say that this note basically refers to the outside of the school?
I can't say
removal of
that-
snow and ice outside?
In my read of it, I can't see that it refers to anything, and that's why, frankly, I refer to it as a meaningless log entry. It is
So my question about the temporal and the timing, it's really, if you look at this log, it doesn't, I don't know what happened, right?
That's exactly the point, and that's why the defendant city never proved lack of notice.
So it's less of dealing with the time and more about what was put forward before Supreme Court to decide this motion.
That's correct. They didn't sustain their burden.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. Jesse Townsend for the respondents. The city and other respondents did meet their burden here in Supreme Court.
That log is problematic, right? I mean, it doesn't say much.
But, Your Honor, the custodian who wrote the log entry testified about what he meant by that, and that's at 357, 358 of the record. What he testified is, when asked by plaintiff's counsel, so when you indicated ready to receive staff, can you tell me how you determined it was ready to receive staff and students? We inspected the exterior and the interior. And then plaintiff's counsel asked at what time. It might not be exactly at 7, but we would have made that entry, is what he's saying, after that inspection was made. And he continues when questioned about when did he make that entry, or what condition that was catching or describing. It would have been before the students came there. That's described at 358. And when asked,
Counsel, I take it that the very general statement that they've inspected the exterior and the interior, the city's taking that to mean specifically the main office?
yes, Your Honor, because there's additional testimony about what he means by that. So, for example, at page 349 through 350, he talks about the timing of when he did that, when his staff would have done that inspection. So between 7:30 and 8, questioned by plaintiff's counsel, do you inspect any of the offices that are used by staff? Answer, yes. During open, and then asked again, what do you mean by that? He says during opening. And asked again, timing-wise, and the answer is around 7 a.m. Then there's additional testimony about
What's the testimony that points directly to them cleaning, or the last time that they cleaned in the main office?
So there is testimony to that as well, and that is...
Is the problem with the testimony that he indicates in answering it would have, which makes it seem as though it's a general answer about what the general practices would normally be versus what was done on that day?
Your Honor, that would be an issue if that's where the testimony stopped. But then when questioned about the log, he said, and this is the man who wrote that log entry, he says that that's what this means, is that we followed our procedure that day. And I do want to get that citation about the cleaning interior, Your Honor.
Counsel, I would like an answer to my question, but I don't want you to use up all your time.
Yeah, I apologize, Your Honor. It is in his testimony about...
I'm looking out for you, because the clock is ticking.
And I'm happy to submit a letter.
A few more seconds.
His testimony is that when they start cleaning the snow from the exterior in, they start as early as, I believe, 6 a.m. on the exterior. By 7, they are moving interior, and they are moving office to office, inspecting, and if they see moisture, they collect it. I'm happy to write a letter.
But that happens after everyone has arrived, that they go in inspecting and mopping up, drying up the area.
That's describing a secondary inspection. He describes an initial inspection starting as early as 7 a.m. Between 7 and 8, they're doing this initial inspection on the interior, because the exterior cleaning has happened even earlier than that.
I mean, is he part of the process? I mean, one of the arguments I heard is he has no personal knowledge of what's going on because he's delegating all these duties.
He's the supervisor, so he's delegating to his staff. And
Did he make the logbook entries?
he did make the logbook entries, the relevant ones. There are some earlier ones from a different day that he says were made by someone else because he was on vacation for those that day.
Did he make those entries based on his discussions with the other employees?
He says he made that entry after the school was ready to be opened. So,
But is he the one that is actually doing the inspection, or is it someone else doing the inspection and letting him know we did the inspection?
it's his staff. He personally is not doing the inspection.
So he's relying on the staff to have done the inspection. So whatever entries he's making is not something that he has personally observed, but something that he has been told by someone else.
Correct, Your Honor. He, as the supervisor, he has people reporting to him that are collectively cleaning this 9,000 square foot school. And he has testimony both about the general process, but as well as that it was done that day based on his notation and his understanding of what that notation meant, that they had made it ready and done the interior cleaning between 7 and 8 before the plaintiff fell around 8:50.
So your argument is that while there are generalities listed within his testimony, he did go to specifically what happened on that day by explaining the logbook entries?
That's correct, Your Honor. If he had stopped just at "we would have done X," that might not be enough under this court's case law. But then when shown the logbook and asked, "What did you mean by this?" he says, "That's what I meant by this." That's the remaining piece that connects that general procedure to what was done that day.
Thank you.
We ask that you affirm. Thank you, Your Honors.
Your Honors, from the questions from the bench, I see that the court readily understands the case. If there's nothing else,
Okay.
I waive.
Thank you very much.
Thank you.
Okay. Tor Central versus Thor 38.
Good afternoon, Your Honors. Joseph Lee Madelon for the defendant respondents. This was a frivolous appeal, and I'm going to make a 2 or 3 minute pitch to urge this court to sua sponte issue an order to show cause as to why the appellant should not be sanctioned.
Make that motion down at trial court, okay? We got enough work up here.
And that's exactly the point.
Order to show cause.
That's exactly the point. This court is so busy that you didn't even have time and shouldn't have had time to entertain this appeal.
Be careful how you throw the lightning bolt. We got it. Anything else, counsel?
Have a great day.
Thank you. Have a good holiday. People versus Christopher Santiago.
Good afternoon, Your Honors. Legal Aid Society by Catherine Picor on behalf of Mr. Santiago. Ever since his arrest in July 2018, Mr. Santiago has been continuously living a law-abiding life in the community. First while he was out on bail and then on probation. And during that time, he's attended treatment, maintained sobriety, as well as steady employment.
When is his probation completed?
Sorry, could you repeat that?
When is his term of probation completed?
It should be April 2024, which means that any sentence reduction would be tantamount to time served and would get him off probation immediately, just a few months earlier than he otherwise would. I believe this modest sentence reduction is well-deserved for a variety of reasons.
Does the defendant have an opportunity to go before the trial court to ask for a reduction in the probation or the shortening of the time of probation?
I am not sure about that, Judge. I don't have the answer to that question. However,
He can seek to have his probation terminated early. It's a normal practice.
well, that doesn't change this court's discretion to look at all the factors that were in the record below and evaluate whether the maximum probationary term
No, but the
is-
problem is there was a plea here, correct?
Correct.
There was a plea, and there was a waiver. I mean, that's why my colleague says that, you can go back for the trial court because then the waiver won't even be an issue. You can ask the trial court for a reduction in time on the probation.
Well, my adversary doesn't even attempt to defend this waiver, so I'll just point that out. But first off, I think there is plenty in the record for this court to reevaluate this case. One thing I'll note, we now have the benefit of time. Again, it's now been over 4.5 years. He's been on probation. Obviously, no violations. He's doing very well. The other thing is that now in the last few years, correctional experts and researchers are starting to reevaluate, as you know, these long terms of supervision, and that does include probation. There's nothing that 5 years of probation is going to do for Mr. Santiago or the community that 4 years of probation, or in this case, effectively 4.5, won't do equally well. And just to briefly address the conduct, yes, these are serious felony offenses. However, these, like his 2 prior misdemeanors, are possessory offenses. He has no history of violence. There's no interpersonal threat here involved. He actually has earned half his credits toward a college degree. He has consistently maintained employment throughout the pendency of his case to this day. He's a very hard worker. Really, all the evidence in the record points to the fact that this is an isolated incident related to his drug addiction, and now that he's had the opportunity for programming and treatment on probation, he's excelled. So
Was he not on probation when he picked up this offense?
No, Judge, and that is something that the pre-sentence report gets wrong, actually, and I believe respondent gets wrong as well. So if you look carefully at the dates, he committed this prior misdemeanor before his arrest in this case, but the conviction came after. So the probation department was laboring under the misunderstanding that he had essentially violated probation by committing this offense, and that's not true. He was never on probation before he committed this offense.
How old is this defendant?
How old?
Yeah.
I believe he is, I don't have that information off the top of my head, but he was, I think, 34 at the time of this offense.
So basically, he had an open case when he picked up the new case. That's what you're telling me.
I'm not sure if he had been charged yet. I don't have that information at my fingertips. That was a misdemeanor drug possession offense, so it was for possessing a small amount of drugs for personal use. But again, I think that it comes close in time to this offense, and I think it all goes together with the fact that he was dealing with an untreated addiction at that time. And as soon as he got on probation, as soon as he had the benefit of probation, he's clearly benefited from that, and he is not, if he were going to violate, we would know it by now. It's been over 4.5 years. And essentially all we're asking for is a few months off the maximum term of probation that he would otherwise finish out.
Thank you.
Good afternoon, Your Honors. Excuse me. The court in this case offered defendant a very lenient sentence considering his conduct. He was caught in possession of 90 methamphetamine pills as well as a host of other drugs, and not one but 2 pairs of brass knuckles, but he received a term of probation, no jail time, even though he was charged with multiple felonies. And lastly, before I end, I do want to note that, that there was an open case pending when he was arrested for this conduct. So unless the court has any other questions, thank you.
Thank you.
Your Honors, I don't dispute that Mr. Santiago does have 2 prior misdemeanor convictions. However, 2 misdemeanors and 1 felony committed between 2016 and 2018 when he was dealing with this drug addiction, I think are a less relevant indicator of his conduct than the last, I believe it's over 5.5 years total that he's been in the community without a new offense, going to treatment, going to work, doing all the things that he's supposed to do. At this point, that's a far better indicator.
Thank you. JT Magellan versus Nissan North America.
Good afternoon, Your Honors. May it please the Court, Y. David Scharf of Morris & Cohn for Appellant J.T. Magan. I would like to address really 3 things with this Court. The impermissible fact-finding that the motion court engaged in on a motion for summary judgment. 2.
What's the impermissible fact-finding? Your client, if I'm not mistaken, said, yeah, we everything's fine here, we're good to go. They paid us. Why is that an impermissible finding of fact? That's what they admitted to, no?
So, no, that's not correct.
Well, that's what the record shows.
No, it's an oversimplification of what happened and a demonization of a victim here.
Isn't that what the waiver said? The waiver that your client provided?
So the waiver, like all waivers that are provided at a time with the expectation of receiving payment.
The Georgetown waiver.
Sorry?
The Georgetown waiver, the second waiver. That Georgetown demanded, saying, we're not paying a dime until we get a waiver that says you've been paid and everything is good to go.
Right, and the Georgetown waiver is impermissible under lien law section 34 to be enforced against the party who is being asked and being told, if you sign this, I will pay this, because it is the public policy of this court. It is and the holding of this court.
Wait a second, you're saying that's a public policy, so he's going to instead, he says, oh, I was forced to sign it, so I had to sign it when I knew it was not true? Because it says that I got paid?
How is that void against public policy? I mean,
Because the Court of Appeals in 159 MP Corp. Versus Redbridge cautioned that courts should be careful that when you're dealing with requests for payment and a lien waiver and a release and a demand that you have been paid in order to be able, that turns the
Okay,
entire...
Counselor, let's get to the practical point of view. Georgetown made the payment on the TIA, right?
They did.
$6 million to the non-party here.
To BICOM, correct.
BICOM,
The bad
correct.
guy,
So
correct.
now, basically, in this lawsuit, the plaintiff is saying, you got to pay us the $6 million, right? So then, at this point, the defendants are going to be paying $6 million twice.
Yes, Your Honor.
And how's that? Shouldn't BICOM be the guys that everybody goes after?
Well, everyone should go after BICOM. BICOM is in bankruptcy.
Oh, yeah, well, yeah,
So it has bankruptcy protection. However, what lien law section 34 says...
But the defendants have no protection then, basically. They're going to have to pay up $6 million.
Georgetown actually does. And
What's
the
their
protection they have is in their contract. Therein lie one of the most fundamental...
Who do they go after for the $6 million?
It's not who they go after, it's how they protect themselves. The contractor can't protect itself, so lien law section 34 and the New York State Legislature says we are not going to hold the contractor responsible for the things that it signs, but the landlord and the tenant, they can enter into an arrangement that explains exactly how the flow of money is going to go. And here...
Well, Counselor, wait a minute. When you're saying that the contractor can't protect themselves, the way I look at it is the contractor can protect itself by saying, I can't give you this Georgetown waiver, which means that nobody gets paid. BICOM won't get paid. They're not going to get the $6 million, right?
That's incorrect because, and that goes to the heart of the lease provision. The lease provision, your question and the motion court's decision in deciding that there was a fraud necessarily has to say that this was a reimbursement provision. And what BICOM and my client JT Megan was trying to do was change that and get them to give money that they weren't obligated to do. But if one looks at the lease provision, it is an advancement provision. There was an obligation.
Right, it's an advancement provision, but it was never handled that way. And to the extent that it wasn't handled that way and it was handled more as a reimbursement, that's BICOM's claim, correct?
That is BICOM's claim. I mean, BICOM actually pointed that out, and that was in the depositions. BICOM said, look at section 3.03. I don't have to give you canceled checks. And the canceled check notion is what is core to the issue here about who has the ability to protect themselves. Nissan and Georgetown have the capability of entering into a lease provision with its tenant, who it is trusting, to perform the tenant improvements and say, no, we're not trusting you with the money.
We're talking, the dispute here centers on the final installment of the allowance, right? We're talking about December allowances, right? I mean, there were two requisitions, 4 and 5?
There were two requisitions 4 and 5.
And those were the final?
No, they were not the final requisitions. There was continued work for December, January, February, March, and April. My client didn't leave the job until April when they turned over substantial performance when they were able to open up the showroom for phase number 1. So what you have here is our client continued to perform work. They haven't been paid. They filed a lien waiver for the work that they performed for which they had not been paid, which what the motion court tried to do was turn...
Is that accurate? Had they not been paid for the entire amount of the lien that they filed?
They had not been paid for the entire amount of the lien that they hadn't been paid. They were not paid requisitions 4 and 5, which was given in November and December, and they were not paid for anything going forward for January, for the work they did in December, January, February, March, and April. They walked off the job, and they then said, we have done everything we can. We have been waiting for payment. And this is the quintessential case, and I recognize my time is up, and if I can at least conclude with this or answer any...
And then I have another question when you finish your sentence.
Sure. So this is the quintessential situation that the New York State Legislature was trying to prevent. Somebody telling a contractor, you're going to get paid immediately. And those were exactly the words. Sign this, and you're going to get paid immediately. In less than 1 minute, they turned around the document and said, here, pay us immediately. But the state...
Okay, so tell us, how did the court get it wrong when it found that JTM modified the records to show a 0 balance was that not the case. So how did the court get it wrong when it found that?
So in multiple ways, but I'd like to focus the court on the notion of reasonable reliance.
No. I'd like you to answer my question.
Guys, try. You got to answer.
My question is so clear.
I apologize.
No. How you apologize, actions speak louder than words. So my question was, how did the court get it wrong when it found that JTM modified the records to show a zero balance when that was false? That's the question.
It actually didn't show a zero balance, because if you look at the record at page 4329 and 3885, it still shows that there was a balance due of 3 point.
That's correct, but it didn't change it to show that there's no balance on requisition 4.
Right.
No, it changed requisition 4, and
that's incorrect.
Yes, but the testimony was the testimony that was given by Georgetown was they didn't look at requisition, they didn't look at the invoices, they only looked at the lien waiver, and had they looked at everything that they had in front of them, they wouldn't have paid anything, because it didn't add up and it didn't make sense.
But that's sort of missing the point. The point is not what Georgetown did wrong in terms of our question. The point is, how do you justify your client giving information that is false?
And you hold that thought for your rebuttal. Thank you. Nissan, North America, and Philadelphia Indemnity. Georgetown's go. Okay. Be careful what you wish for.
Thank you, Your Honors. May it please the court, Josh Hollander with Caswitz Benson on behalf of Georgetown 11th Avenue owners.
So let me ask you first. This lease agreement is between Georgetown and Bicom.
That is correct.
Has nothing to do with the contract, JT Majan, right?
That is correct.
So that if there are any changes with respect to any of the protocols or procedures on how the TIA is paid out, that's between you and the tenant, and that's it, right?
Well, right, Your Honor.
If you ask the tenant, I want my Georgetown waiver in addition to what I have, and the tenant complies, well, what else, right?
Well, Your Honor, JT Magan and Bicom knew that Georgetown was going to be reimbursing the TIA money, and that's when JT Magan and Bicom hatched this side deal where JT
the 20%, they get the 20%.
to stop working on the
Well, besides all that, my thing is how did we change the protocol? Because the protocol seems to just suggest that you didn't have to give the Georgetown waiver, because that's the critical point. Georgetown demanded, before I release any funds, I want a Georgetown waiver, which says that you got a zero balance because making sure that Bicom paid the contractor. Because I'm not advancing money, I want to reimburse money, right?
Sure, but JT Magan knew all of this. When we asked Morris Reagan, the CEO of...
Well, regardless of whether they knew it, they couldn't do anything about it, right? I mean, JT Magan, they didn't have control of the contract between Georgetown and Bicom, right?
Right, but JT Magan did know that if there was going to be any open balances, Georgetown would never release the funds. So the invoice that was doctored, Your Honor, I mean, if you take a look at these two invoices, the original invoice is in the record at 1702.
I don't think there's a dispute that it went from some number to zero.
Right. And they literally removed an open balance. On the bottom of the invoice, there's an arrears, and it says what invoices are open. JT Magan literally deleted them. The person who deleted that invoice, the accounts payable manager, Josephine Crespo, she testified at her deposition that she would never remove an open balance that hadn't been paid unless she was instructed to do so by an officer of JT Magan, which was Morris Reagan.
Is it your contention that that was removed because they wanted to ensure that Georgetown made payment to Viacom, and Viacom and JTM had a separate deal where they would get the additional 20%?
Right, but JT Magan knew that the TIA money would never be released if there was any open balances, and that also applies to the
despite their attempt to make it seem as if there was no open balance, there was evidence that there was an open balance.
Well, Your Honor, so this is actually very important. Georgetown received the invoice that had the open balance. Georgetown rejected the request and said, we are not going to accept this because there's an open balance. That is when that's when Bicom emailed JT Magan and said, I need you to revise the November invoice to show the October amount paid. That's in the record at 1701. Then JT Magan removes the open balance, sends it back to Bicom to give over to Georgetown. when the doctored invoice or the falsified invoice was sent over to Georgetown, there was a representation made that said, here is the new invoice showing no open balances. That was a false statement. At the deposition of Jonathan Schmieren, Georgetown's principal, they showed him the true invoices, the ones that said open balance. And they said to him, if you had documents that show an open balance, why would you ever release the money? They didn't show him the false invoice, the one that actually was submitted after the fact when they removed the balance. So the fact that there was an invoice that showed an open balance, the events that happened afterwards were critical because Georgetown rejected the TIA request. Bicom and JT Megan turned around, removed the open balance, sent it back to Georgetown, said, here's the new invoice showing no open balance, gave the December 2nd lien waiver, which is the Georgetown waiver that says all subcontractors had been paid, JT Megan had been paid to date. That's all false. There's no dispute about that. And then and only then did Georgetown release the money. This is also relevant to the canceled check issue. When Georgetown received the initial request for TIA 5 that showed the open balance, and Kevin Michelon said, we're going to reject this. We want to see canceled checks to show proof of payment. Then and only then did JT Megan and Bicom then remove the open balance, send the falsified invoice back to Georgetown. At that point, Georgetown didn't need canceled checks. They had documents that said everyone's been paid, all the open balances have now all of a sudden magically disappeared, and then they released the money.
So quickly, what is your response to that this violates the lien law? What you're asking for, the Georgetown waiver violates the lien law?
Well, so, Your Honor, Mr. Skelton is going to address this conditional versus unconditional lien waiver and lien law 34. But what's critical is that the lien waiver, for purposes of our fraud claim, it doesn't matter that it's a lien waiver. It could be a waiver, it can be a document, it can be a piece of paper. The fact is that piece of paper that was signed and notarized by JT Megan had false statements in it. The enforceability of the lien waiver, that is, did JT Megan waive its right to now seek the money that it waived, which it's doing now, right? They waived Recs 4 and 5, and Georgetown paid that money. Recs 4 and 5 are now in the lien that they're trying to enforce, so we would have to be forced to pay twice.
Oh, I said that.
That inquiry goes to willful exaggeration. Did they inflate the lien? Did they include waived amounts? That inquiry is separate and apart from whether or not that document contains false misrepresentations that Georgetown relied upon, and the answer is they did rely on.
Counsel, to the extent that Georgetown unilaterally changed the scope of the agreement from being an advance agreement to a reimbursement agreement, let's just assume that. What's JT to do about that?
Well, Georgetown did not change any agreement. If you
just assume it from my question.
Assume that was done.
It's
not a trick question. Assume that
if Georgetown changed the requirement from advancement to a reimbursement,
yes,
how would that affect JT Megan?
What could JT do about it?
Well, JT Megan was in the know and knew that they would never get the TIA money if there were any open balances. Bicom and JT Megan
I think you're missing I think I get what he's asking is, does JT Megan have any rights to challenge that change in the contract between your client, Georgetown, and the tenant? And Bicom. If they agree amongst, he knows the answer. It's not a trick question. It's a straightforward question.
What would you, I don't.
Okay, we got it. Thank you. Well, he's jumping out of his seat to answer the question, so we'll let him answer the question. He'll fill you in later after the argument. Go ahead, Kyle.
Good afternoon, Your Honor. May it please the court, John Skelton on behalf of Nissan North America and Philadelphia Indemnity. I think the answer to your question is JT Megan would have had no recourse other than in November of 2016, and the record's replete, in November of 2016, Bicom hadn't paid JT Megan a ton of money. They were way behind. Maurice Reagan and JT Megan had an option. They could have walked off the job and filed a mechanics lien. And that mechanics lien would have been for about $4.5 or so million. We would not have a consent issue. We would not have unclean hands issues. We would not have equitable estoppel. We wouldn't have a
waiver issue.
We wouldn't have a waiver issue. But JT Megan made a business decision that they were willing.
But what about your adversary's argument that This is what happens in this industry.
Well, what I would say is that Justice Cohen, Supreme Court, has been dealing with this case for 5 years. 2 summary judgment motions, this one being the most recent, right? All of the arguments, all of the evidence, and if you look at his decision, my God, is it thorough, and you look at the number of NICEF entries that he reviewed, it is, I think, approaching 200. So all of those arguments were made and rejected. And if you read his decision, he says that, in short, the summary judgment record presents a clear case for application of the unclean hands, equitable estoppel, and willful exaggeration defenses as can be imagined. Those are strong words from a trial judge who spent an inordinate amount of time considering everything, including all of the arguments here. I do want to get to one issue that's specific to Nissan, but it relates to the notion of substantial completion, and it relates to the issue of what Nissan got for value. In their brief, in their opening brief, on page 57, and I thought this was kind of incredible that they would make this statement. They say that if you affirm Justice Cohen's decision, that leaves Nissan in a well-appointed premises they are using to sell luxury cars they got without paying J.T. Megan. On April 10th, when they walked off the job, and if you look at in the record, 600 is their memo that says, hey, we're done, we're walking off the job. And it is crystal clear, we are not starting phase 2. If we go over to 787th, 11th Avenue today, the portion of the building, the half that was supposed to be created for Nissan, is empty. It is vacant. They never did any work on the Nissan portion. And that's important because counsel said, hey, we continued working from December, January, April, or February, March, and April, right? Another $4.5 million, which is the second component of the lien. They want Nissan to be responsible for paying for that, while throughout all this time, Nissan was over in federal court before Judge Swain trying to terminate the sublease so it could try and take over this property. Lien Law 34 specifically says there's a public policy that says you can't put in a contract, a waiver, an advance waiver. But there's nothing that says that as you go along, you can't require waivers. And here, the relevant contract, J.T. Megan and Bicom, didn't have any kind of lien waiver provision in it.
That's why the contract talks about conditional waivers or, inchoate waivers, because according to lien law, you can't put a waiver in it doesn't say you can't put a conditional waiver, right?
Right, and the relevant contracts for purposes of the parties before your honors now is the leases, right? And if I am a landlord like Georgetown and I say I'm going to give tenant improvement monies, I can absolutely condition before I pay out to make sure that I'm not subject to a lien. And that's what was going on here. And I'll end with this, because I think that on page 14, Justice Cohen summed up this case and the issues that I think are critical. Neither the case law nor the evidence in this record support JTM's suggestion that the submission of false certifications of payment to Georgetown was consistent with accepted industry practice. The bottom line is that JTM cut a side deal with what turned out to be an unreliable entity, Bicom.
Well, he finished that sentence by saying, especially when the property owner is uninformed about the deal that's going on.
Exactly. And at any point in time, and I think this goes back to your honor's question, right? J.T. Megan, if they had stood up and said to everybody, hey, well, wait a minute, I'm not getting paid. I shouldn't continue to work because Bicom can't pay me. Well, Georgetown and Nissan would have said, that's between you guys. We are not going to fund this case other than our TIA monies, and we're not going to allow you to continue to rack up unpaid balances. I mean, when Justice Cohen looked at the issue of consent, he said that side deal fundamentally changed the project because those leases had three essential components. Number one, they were supposed to be done lien-free. Number two, you weren't supposed to have financing. And number three, you were supposed to be getting paid monthly ongoing. Because no landlord or property owner wants to let a contractor rack up $4.5 or $5 million worth of unpaid bills, and then if their obligor walks out on it, files for bankruptcy.
Got it.
Then
Thank you.
I see that my time is up. Thank you.
Yeah, thank you.
Justice Rodriguez, if I can come to you, to your question. It's not just me who's arguing that it's not fair to us. The New York State Legislature has said these lien waivers, we want to call them conditional. Justice Oing asked about conditional, Georgetown, unconditional. The law makes no distinction. This court in Graciano and all the other cases that have followed made it very clear. Nothing you sign matters unless you've gotten the money that you say you've gotten because of the inequitable balance of power between the contractor. They're saying the contractor should...
But isn't this exactly what Georgetown was asking for? A waiver that, or an acknowledgement from J.T. Megan that they had actually been paid.
And they said that they hadn't been paid.
That's not what the waiver says. They signed saying, we have been paid and all of our subcontractors have been paid. It even lists the amount that they acknowledged they had received from BICON.
And zeroed out invoices to reflect having been paid and there being no open balance.
The submission, the last submission that was paid by Georgetown, which included invoices 4 and 5, did not show there was zero balance. If you look at the entirety of the package, it showed that...
Well, did it show that there was some payment had been made?
It showed that there was over $3.5 million that was due on invoice
Did it show that there were payments made?
And there had been payments made. In fact, the history between the parties showed that BICOM had previously, as it related to requisition number 2R, and which had the corresponding BICOM number 3, those showed that BICOM actually got paid before it paid JTM. So we
think that side deal that your client did was unusual, or that's a typical industry practice?
It's actually not unusual because the it's not just my argument, it's state legislature and the courts that have all invalidated any statement, because this is what I think is the gaping hole in the logic here. State legislature says there's an imbalance of power, therefore we're going to rectify it. And what's the imbalance of power? What had been happening was contractors were being pressured to sign documents that were inaccurate. If the argument is every time a lien waiver is
Whoa, wait a second. Hold a second. You're saying contractors are being pressured to sign documents that are inaccurate. In this case, the contractor signed a document that they themselves made inaccurate.
They were told to get immediate payment, sign here. And that's the balance.
Yeah,
and that's what they were told.
And the response to that was, you know, don't put in a document like that and just say you're not going to get paid. And I think counsel gave a good example of what happens next.
But that's the case in every, and I recognize my time is complete, but if I can answer
We got it.
this
Thank
question.
you, thank you, Mr. We got it. Thank you. People versus Mamadou Coulibaly. I'm sorry if I messed that up.
Coulibaly.
Oh, you say it.
May it please the court, my name is Amy Donner and I represent appellant Mamadou Coulibaly. I plan to address both points, but starting with the value of the stolen property, the weight of the evidence did not show that the value of the 2 cell phones, which were display models, store display models for handling by customers, that it exceeded $1,000.
Isn't that the amount of whatever price was listed on these phones? Isn't that what the witness, I don't know if it was St. Louis or the other one, Truman, I believe?
Yes, Your Honor, it is.
Isn't that what one of them testified was actually the sales price of a similar phone?
What she was talking about were the most natural reading of her testimony, which is conclusory, is that she was not talking, that she was just talking in general, but these were display models. They were connected to security devices. At least one of them was marked not for sale. And they were, if you look at the photos, which the people introduced, they're scuffed up. There's writing worn off by them. They're tethered to shelves.
Did that happen? Did that happen after the defendant here, Mr. Coulibaly, yanked him from the wall, and as he was tussling with the store employee, trying to prevent him from taking back the phones?
It's certainly one of them was marked not for sale. That had to have happened before. And so the most natural reading of her testimony is that she was just talking about in general. And certainly under any standard of review, and certainly weight of the evidence includes an elements review, which Danielson has said, and so have appellate division cases. There's that was not the type of phone. That was not what the type of phone like these, that she was talking about. The most natural reading, and certainly the photos show phones that are not in great condition. So it's very conclusory, and the testimony is just very conclusory. So going on, so even. Let me see. And just, these were phones, these just weren't the kinds of phones display models everybody knows are not the type of phones, do not have the same value as something that's nice in a box in the back. It just doesn't. So that's just sort of common sense. Additionally, in terms of the robbery, I urge your honors to really look at the tape.
I saw the
Because
video. We saw the video.
Good, I'm very glad, Your Honors.
I'm not so sure you should be glad about it, but we saw the video.
Well, Your Honors, I would really urge you to look at,
There's some serious struggle right by the door
but
with the two employees.
But one phone falls out of his pocket immediately.
By accident. He didn't toss it. It fell out of his pocket. And then he held on to the other one.
He held while taking a swing at somebody else. I told you not so good about seeing the video.
Even after, as one looks at the video, though, it really compromises.
So that video, certainly there was no time on the video where the defendant either returned or attempted to return either phone. The first phone that fell out the pocket, and then the second phone when he was going to the door and held in his hand. The video didn't show an attempt to return or a return. Is that true?
But that's not the standard, Your Honor.
No, I just asked you, is that true? That's a yes or no.
What the video shows.
That's a yes or no. Did the video, we're going to do it this way. Question 1A. Did the video ever show defendant return either of the phones, phone number 1 or 2? That's a yes or no.
No, but.
Okay, now 1B. Did the video show an attempt to return either phone? Yes or no?
No, but what the video does, but first of all, but that's not the standard, Your Honor.
I didn't ask you
what
about the
they have to show is that, what it does show is that he's having a reaction. He continues fighting. The second phone is out of his pocket. One falls out of the pocket. The second one, the one that you're saying that he's holding for dear life, that one is held. That one, he continues the fight after.
Counsel, you have rebuttal time. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Connor Burns for the people. The trial.
Counsel, how do you respond to your adversary's argument that, in terms of value, one of them is marked not for sale. They're both display phones, which, I think it's sort of understood that items that are on display have a different value than a brand-new item?
Sure. So first, in terms of the sticker, the not for sale sticker, certainly that may have meant that at the time the phone was not for sale, but that doesn't mean it doesn't have any value. Certainly it held value to the store because it was tethered to the wall. It wasn't just given away for free. So certainly the store still valued the phone. And that not for sticker sale was, looked like it was adhered to the phone
And
by
the
Scotch.
employee testified to what she thinks the values of these, I mean, that's what they do. That's their business, right?
Correct. And the witness certainly testified, and the jury saw the photos. They could have taken that into consideration, but still felt that they credited the witness's testimony that the phones exceeded $1,000 in value, the aggregate value.
Combined, right, the aggregate.
Sure, yes, the aggregate value of both phones, I think each were valued at $749. And going to the deterioration of the actual model of the model phones itself, sure, there may have been some wear and tear that the photos depicted. I don't think to the extent that defense counsel suggests, but even still, the jury could still infer that, the value was $749 each. So in order to fall below the $1,000 threshold, each phone would have had to have deteriorated more than $250 each. And I think the photos show that the phone was in good working condition. The screen was illuminated. It showed the date, the time, the battery, application, icons. So certainly the jury could have weighed that evidence and did weigh that evidence and credited the witness's testimony that the phones did exceed the $1,000 in value. And just briefly to turn to the robbery conviction, I think as your honors have hinted at, or you've seen the video, certainly there was force used. The defendant was, while one of the phones did fall out of his pocket, he did have one of the phones in his hand, was fighting with the store clerk, pushed him multiple times, hard enough to knock his eyeglasses off, his shoes off. He almost made it out of the door with one of the phones in his hand. So certainly the jury credited his testimony and saw the video and infer that he was using that force not just to escape, but certainly to retain the possession of the stolen property. And if there are no further questions, we ask that you affirm. Thank you.
Thank you.
Your Honors, even a phone that, just because a phone can make a phone call, it can be completely crappy, and there's no way that anybody would pay for both those phones something that exceeded $1,000. And that's what the element was. That's what the people had to establish. And you just don't have that.
Someone paid $1,000 for the two phones combined.
$1,000, yeah. They'd have to prove that the aggregate value of this not-for-sale phone and two scruffed-up phones that were for display and tethered and attached to security devices, that somebody would pay, that they would have to prove the element of over $1,000. And it clearly does not establish that in this situation. With this conclusory testimony, it just doesn't. And just concerning the other point, the only thing I wanted to just finish that sentence that I was saying at the very end, which is just that the fight did continue after he had nothing, after he was no longer holding either phone. That's all I was going to say about that. Thank you, Your Honors.
Thank you very much. Wright versus City of New York.
Good afternoon, Your Honors. Kevin Fitzpatrick for Appellant. May it please the court. Your Honors, I'm seeking reversal of the lower court's order denying my motion to dismiss Porsche Properties 2 LLC from the lawsuit. My client is an out-of-possession landlord that owns 930 East 174th Street. An affidavit was submitted by the managing agent stating that he did not have any complaints about the sidewalk adjacent to 930 East 174th Street. And he also stated in his affidavit that he did not hire any companies to perform repair and maintenance work to the sidewalk. In addition, he said that he did not have a special use.
So the photographic evidence in the record shows is sort of the area that was pointed to. There was a lamppost there. Am I looking at the right photo right? There's a lamppost there.
Yes.
There's a little depression there. And that kind of falls smack in the middle of your client's property and the other property, right? It's sort of like that's where it's at, in the middle.
I believe that.
I kind of looked at it and I'm like, okay, it's sort of in the middle. And they amended their complaint because I read the record here where there was a mistake.
You know, it should have been not only 9:20, but we should have said 9:30 also, and that's where we're at, right?
Putting aside the issue that the plaintiff originally said that it was only 9:20, and the fact that she omitted that it was also 9:30, I believe is part of the issue here. But putting that
Is the
aside,
plaintiff consistent about the location in her description of where the accident occurred between the 99-cent store and the Spanish store?
I believe she was not consistent. Her notice of claim, her 50H testimony, her complaint, her bill of particulars, and her affidavit in support of the default motion all only said 9:20, and it did not say anything about between. In fact, the word between does not appear in any of her pleadings.
So
Doesn't
we're
even
going,
appear in her
I
affidavit.
think, far afield, because this is a 3211 motion, right? It's a motion to dismiss on the pleadings, A1 and A7, right? It's not a summary judgment motion, right?
It's not summary judgment.
So they served an amended complaint, which ostensibly corrected the 9:20 versus 9:30 error by now saying both 9:20 and 9:30. So if assuming the facts to be true, why doesn't this pass the pleading stage and you go at it for summary judgment saying, look, you know what?
I can address
So what I'm hearing here sounds like more summary judgment than attacking it on the face of the complaint.
I can address that, Your Honor, because let's assume arguendo that the alleged defect is on the sidewalk adjacent to 9:30. My client in his affidavit said he had no complaints and he didn't hire any company to.
Well, that's kind of self-serving at this point with an affidavit, right?
That's his testimony.
Because we know now, on a 3211, you can use affidavits to expand and sort of fill in the gaps that a complaint have, but you can't use an affidavit to dismiss a 3211.
It has to utterly refute the allegations of the plaintiff, and plaintiff must establish either notice or that we caused and created. Actual notice in this situation.
Wait a minute, but they pleaded that in the complaint, right?
But they have not, it's utterly refuting her allegations.
Oh, you're getting down to, I think, a fact issue here now. You're getting down to summary judgment when you say that, when you make that argument.
If
your only thing is you're pointing to the owner's affidavit to say, that's it. I'm entitled to dismissal of the complaint because my affidavit utterly refutes the allegations set forth in the complaint.
in conjunction with his lease, it shows he's an out-of-possession landlord, and he says he didn't have any notice and he didn't cause or create.
There's a Court of Appeals precedent that kind of whacked us and says, no, out of possession, you know what, there's non-delegable in terms of sidewalk defects. So out of possession doesn't, I was on that case, trust me, I remember getting reversed like that. So.
It's non-delegable, but they still have to show notice, and if he's saying that he didn't have notice, then that utterly refutes the allegation that he had notice. The plaintiff respondent is not here, the city is here, but I would just add that on page 156 of the record, the plaintiff testified under 50H that she gave notice to the city. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. Rebecca Viscatus for the City of New York. As Your Honor recognized, the amended complaint here plainly stated that the accident took place in front of Portia's property as well as the property next door. Also, as Your Honor was getting at, the affidavit submitted by the managing agent does not come close to meeting the standard of utterly refuting plaintiff's allegations.
It's not documentary evidence. In my mind, it's not. I mean, you know, you can use it to amplify a pleading, but you can't use it to prevail on a dismissal motion.
And the city completely agrees in this case that that affidavit under the Second Department case law that appellant refers to in their briefing would have to show that a material fact as claimed by the plaintiff was not a fact and that no significant dispute existed.
You don't have to rely. I expect the second, but we got First Department cases that say that too.
So as Your Honor was pointing out, this is something that really is to be litigated later on as this case progresses. Portia is trying to litigate factual issues based solely on the complaint and its own say-so.
Yeah, I mean, his complaint, his argument about being an out-of-possession landowner, that doesn't fly very far, given the Court of Appeals, decisions on that in terms of non-delegable duty.
Exactly, Your Honor, and the statements about not receiving any complaints are not worth very much when we don't know anything about whether he conducted any searches, how long he had been managing agent.
Has there been any discovery from Portia?
Sorry?
Has there been any discovery from Portia?
I am not involved at the trial level, but I don't believe so. And I believe that.
This is a pre-answer motion to dismiss.
Exactly. That this is a pre-answer motion, that I believe Portia may be trying to avoid discovery, but this is a classic situation where discovery is needed. If there are no further questions, the city asks the court to affirm.
Thank you.
Briefly, Your Honors, the case law I cited states that affidavits may be used freely in a 3211 motion. There was some opposition that it couldn't be used on 3211A1, documentary evidence, but it can be used 3211A7, failure to state a cause of action. And if the court merely looks at the photographs, you'll see that the defects and the cracks are on the side of the Spanish store, as they called it, not the 99-cent store.
Great,
Thank you, Your Honors.
very much. Thank you. Bradley versus NYU.
Who goes first, Your Honor?
I guess the first goes, I guess it would be appellant at NYU, right? You guys filed the notice of appeal first.
Yes, that's correct, Your Honor.
All right, so you guys are first up.
May it please the court, Hillary Simon from Kennedy's for NYU and Hunter Roberts. There are 6 issues addressed by our appeal. The first, as to plaintiffs' labor law 200 claims, neither NYU nor Hunter exerted any control over the plaintiff at the time of the accident. NYU was the property owner, they didn't have a representative on site, and they didn't direct or control plaintiff's work.
This is not a, this is a dangerous premises matter, not a means and method issue that we have here. I mean, he didn't fall because somehow someone was doing work that they were not supposed to do. He fell because, according to the plaintiff, there was a dangerous condition, meaning the stairs were wet.
Right, so plaintiff hasn't provided any evidence that there was a dangerous condition, neither
Is it
NYU.
plaintiff's burden to provide that at this point?
Well, it is in terms of, like, for a summary judgment motion, they haven't met their burden, and NYU and Hunter have established that they didn't build the subject staircase where the incident occurred.
Sorry, am I mistaken? Is this your motion for summary judgment?
This is my motion for summary judgment.
Your burden, right?
Who's got the burden?
Right, correct. Yes, Your Honor.
Okay.
That's correct. So NYU and Hunter did not build the subject staircase where the incident occurred. In addition, they weren't responsible for water remediation.
You know, this is a labor law 241 case, right? It's a labor law 241, right? So I thought that owners and general contractors, it's a non-delegable duty on a 241.
Right, so plaintiff hasn't established that 241-6 applies to this case because the industrial code section that they cite, 23-1.7D.
Passageway being slippery or wet, right?
Well, not only that, Your Honor, but also that the subject stairs were the sole means of egress to the site, or was itself a work surface. And
Isn't that
here,
a factor issue? Because I thought the record indicated that there may have been a second staircase, but they wasn't sure if that was accessible for the plaintiff to use on the way back.
The EWBC witness testified at the record 338 to 339 and 761 to 762 that there were always 2 staircases that could be used to access the mezzanine level.
But he said that he was not sure if there was a second stairway to access the second floor. And according to plaintiff, this was the only way for him to access his job site.
It also was not in and of itself a work surface, a work area. So our contention is that 23-1.7D doesn't apply. And even if it did, plaintiff hasn't established that the staircase was rendered slippery by the presence of water.
This is a metal staircase?
Yeah, the subject.
And the roof was open supposedly, and it was raining that day?
So this, there was testimony to that effect. The subject staircase was a steel grate system. Any water would just fall right through it.
It just means that water doesn't pool. It doesn't mean that it's incapable of getting wet.
Right, but plaintiff, the allegation that she's making is that the water had accumulated, and it cannot accumulate on those type of stairs. So, you know, at the very least, there's questions of fact as to plaintiff's 241-6 claim.
We agree with that.
Yeah, which goes to why you shouldn't get summary judgment then.
Well, I'm also addressing his motion as well, but as to 241-6. But moving on to our contractual indemnification claims as to ASR, the first being that the trial court incorrectly found that NYU was not a third-party beneficiary of the subcontract between Hunter and ASR, and they improperly dismissed the contractual indemnification claim by NYU against ASR. The language of the subcontract and the exhibits, as well as the purpose of the agreement and the surrounding facts and circumstances, including the obvious fact that NYU Hospital Centers and NYU Langone were both covered entities under the NYU ASR subcontract.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Zachary Perisman for Plaintiff Respondent Appellant Nakora Bradley. The lower court should have granted plaintiff's summary judgment pursuant to Labor Law 241-6 based on a violation of 12 NYCRR 23-1.7d, the slipping hazards reg. It is uncontested that plaintiff slipped and fell on water on these temporary system stairs on this construction site. And I thought I would be the first one here saying the record is replete, but I am not. And the record is replete here with documentation and logs showing that there was nearly continuous inflow of water on this into this construction site on the date of accident and nearly 1 week prior because of the demolition of the roof, which had not been replaced. Richard Glabaki, the ASR foreman of plaintiff's employer, testified, it's on page 630 and 631 of the record, that rainwater was coming into the building through openings on the second floor and that the water would get on the stairs.
But is this the only stairway to access the plaintiff's job site?
Your Honor, Jason Silverstein of Hunter Roberts testified that, in fact, he testified twice, that if this temporary stair was in place, then that means that any permanent stairway would have been inaccessible at that time. And he reiterated that twice. This was from the general contractor twice in his testimony. And as you, Your Honor, stated before, the testimony of Mr. Zed that defendants have quoted was equivocal at best. He said, I'm not sure. So in fact, the only testimony here that we have that is unequivocal about the presence of stairs and any access to this area was from the plaintiff and from Mr. Silverstein. At the same time, that really goes to the issue of sole means of access. And, Your Honors, the sole means of access case law under the labor law, both for 241-6 and 240 subsection 1, has only ever applied in the context of permanent staircases. And it frankly makes sense under the policy of the labor law because those are not necessarily constructed for construction purposes. Here, we're talking about stairs that were constructed to provide a passageway for the construction workers on this site. And a passageway is clearly covered by 241-6. And here it was wet. And in fact, based on the accident reports and everything else, there's nothing to show that the stairs were not wet. Nobody conducted any investigation. There were no photos. Nothing was done to argue against the fact that these stairs were wet at the time. And therefore, plaintiffs should have been granted summary judgment.
Can you address the comparative fault?
I'm sorry?
The comparative fault argument that they make.
Yes, Your Honor. It is also our position that all affirmative defenses relating to plaintiff's comparative fault and culpable conduct should have been dismissed. All plaintiff did here was go up the stairs holding onto the handrail. There is no argument that she did anything wrong other than walk up the stairs, which were wet because defendants failed to remove the water to provide her safe footing. And without any arguments as to anything she did wrong, those affirmative defenses should have been dismissed.
Has anyone contradicted that statement from plaintiff that she was going up the stairs while holding onto the handrails?
No, Your Honor. No, because no one here has said anything other than the only statements we have as to how the accident occurred are from plaintiff and in the accident reports from her employer and the general contractor. And Your Honor, any arguments defendants have made with respect to the holes in the stairs, as has been stated, their own witness, Mr. Silverstein, testified that those holes merely prevented an accumulation of water, and plaintiff did not argue that she slipped on an accumulation of water. She just stated that she was going up the stairs and slipped on water, and it doesn't mean that those stairs were not wet. 23-1.7D does not go into effect based on some amount of water. It just means that if there's water, it has to be removed to provide safe footing. And therefore, we should have been granted summary judgment under 241.6. And additionally, summary judgment to defendants was correctly denied under Labor Law 200 and common law negligence because, I mean, there is clear evidence of notice, frankly, in this case. And additionally, they provided no evidence as to when this area was last inspected prior to the accident. If there are no further questions, I rest on my brief.
Thank you.
Thank you.
Good afternoon. James Lofreese, Black Margie and Sanford. I am for respondent ASR Electrical Contracting, plaintiff's employer in this case. May it please the court, it's our position that the lower court got it right on all counts. There are issues of fact with regard to 241.6, as much as I would like to deny that, but there are distinctions in this testimony that need to be addressed. Michael Zay of EWBC testified that there were always two staircases. Jason Silverstein testified there were two staircases at one point, one at another, and I'm not sure when that happened. But regardless, it's an issue of fact, and plaintiff's motion needs to be denied because the jury needs to determine whether or not this was the only staircase at the time, and whether there was an accumulation of water. The court also got it right when it dismissed NYU Langone Hospital's contractual indemnification claim against ASR. There is no mention of NYU Langone Hospital's.
Yeah, but doesn't that, I'm looking at my notes here, hold on a second. Doesn't that provision, that contractual indemnification provision, say Hunter Roberts, the owner, and their respective members, partners, parents, affiliates, agents, officers, employees, you might as well go with grandmother, grandfather, I mean, you know, landlords, sub-landlords, property managers. It's pretty broad in terms of who's covered under, I mean, it's pretty, I mean, it's not restrictive. So how do you respond to that?
I appreciate that question, Your Honor. It is true that it extends to members, parents, affiliates, agents, et cetera, of the owner. But there's nothing in the contract identifying or even suggesting to identify that NYU Langone Hospitals is one of those entities. The only contention is that NYU Langone Hospitals has a similar name to NYU Hospital Center. And if the drafters of this contract wanted to include NYU Langone Hospitals as an indemnity, it could have named it, or it could have identified it as an agent or some other way fitting into that classification of entities. It did not. And especially when we're dealing with claims for indemnification against employers, it's important to recognize the legislative intent of shielding employers, giving them immunity against these claims unless there is an express written agreement.
Is your issue that NYU wasn't specifically named or that they don't fit the broad category that's included as indemnities?
Both, Your Honor. They were not specifically named as an indemnity. They were not identified as fitting within that class of indemnities either. As this court stated in Tonking, or I apologize, Court of Appeals in Tonking, when a party is under new legal duty to indemnify a contract that assumes that obligation has to be strictly construed to avoid reading into it a duty that does not exist. We submit that this contract...
That's a duty, you know, that doesn't talk about who. It's just talk about you shouldn't be offering indemnities, you know, which is really true, and that has to be strictly construed, but I'm not so sure you can take that to the next one and take that kind of reading and say it also applies to parties. I mean, here this is the issue right now because it's so broad. I mean, that's something that sort of can be explored or part of some next motion or whatever. I mean, did anybody ever think about that? I mean, you're making that case and it's like, wait a second. I mean, as like my colleague said, I mean, we don't know, right?
Well, Your Honor, to the extent that you're suggesting there's an issue of fact here, our contention is that it's not. It's an issue of contract interpretation and construction. It needed to be clear and unambiguous and expressed in the contract itself. And that is our position here, especially when we're dealing with claims against employers. Finally, Judge, the court properly denied Hunter Roberts' motion for summary judgment contractual indemnification claim against ASR. The record's replete with issues of fact as to whether or not Hunter Roberts, who coordinated the removal of this roof, who did not replace it in a timely manner, who was aware for 8 days or so of an ongoing water infiltration problem, yet made the workers work in this condition, is negligent. We submit they could be found 100% negligent. If there are no questions, I'll rest on my brief.
All right, thank you.
Thank you.
If your honors have any further questions, I'm happy to answer. If not, I'll rest on my brief.
We're good? Yep, we're good, thank you.
Thank you, your honors.
Same thing for the plaintiff?
Yeah, Your Honor. The only thing I will say is just, I just urge the court. I don't think there needs to be any focus on whether there were 2 stairwells or not stairwells, because I don't think that case law even applies here. At the same time, I still think Mr. Silverstein's testimony establishes there was 1.
Got it, thanks.
Thank you. Thank you, Your Honor.
Thank you. Talos Capital versus 257 Church Holdings.
May I begin, Your Honor? James McGuire for Friedman Kaplan. I'm joined here by my colleague Nolia Boyar, who's from Friedman Kaplan, one of the alleged malefactors here. I'd like to begin with, I think, what I may seem like a small point, but I think it's a significant one. In a memorandum of law dated September 30th of 2022, Mr. Smith opposed the plaintiff's motion at issue waiver theory, and he asked the court to appoint a special master to review the privileged documents that were going to be produced. Now, it seems pretty innocuous. I mean, if the special master reviews a bunch of privileged documents and decides that one of them, is privileged and it shouldn't be seen by the trier of fact, and that was going to be the judge, and the judge, doesn't see it unless there's an objection.
Counsel, I think from what I've read in the record here, Supreme Court took issue with the fact that Mr. Ashkenazi takes one position with respect, and this has all to do with timing of his payment, right?
Right.
It's either at maturity or it was at 2018,
right.
the 5-year mark or at maturity, right? And Supreme Court took issue with the fact that with respect to any privilege issues or documents, Mr. Ashkenazi testified that he didn't have to rely on the attorneys because I read the documents myself. I read the whatever loan documents myself.
I mean, that
Wait.
Oh, I'm sorry.
Then the Supreme Court takes position that, or at least says that Mr. Ashkenazi later on reverses himself and says, I never even looked at the documents. And that's where Supreme Court's sort of focusing the ear of this. And then, but what I'm seeing lacking from the record here is any indication that the firm, and your firm wasn't the first firm that came in to represent Mr. Ashkenazi, correct? They came in later. I mean, I think it was Nixon Peabody that represented the firm. So this whole notion of when he was going to pay and any ambiguity was started off with Nixon Peabody, right? I mean, you guys came into the game later on appeal, basically, on the first appeal, which you got it overturned and you got a reverse for summary judgment, right?
Right.
So what I'm lacking in the record here in terms of this is a appeal of the sanctions against Friedman, Kaplan, and Seiler. And I'm missing that there's a disconnect here, for at least in my mind, and maybe you can clarify, was this Mr. Ashkenazi's own volition, or did the law firm actually counsel him to make these kind of
Your Honor,
contrary positions?
There's no lack of linkage here whatsoever. First of all, yes, another firm had been involved. Friedman Kaplan was brought in when the case was in the posture of a pure question of law. What's the interpretation of the agreement? It's an objective question. It's got nothing to do with Mr. Ashkenazi's state of mind. It's how do you read? It's an objective question. What's the best reading of the document? Both sides insist that their reading of it is unambiguous, and that Mr. Ashkenazi doesn't have to pay it until the maturity of the underlying loan. and summary judgment is granted against him. And this court reverses, and it rules that it's ambiguous. So now, and only now, can parole evidence come in. It's Contract Law 101. And after that, it's Mr. Ashkenazi isn't the lawyer. This is all games. This is all word games. Mr. Ashkenazi is not the lawyer. Friedman Kaplan is the lawyer. Now, they've been in the case since like July after the May remand, right? And so they get involved in July, and all of a sudden they're hit with this motion for an attachment by my adversary, which the judge rejects right away because there's no possibility of success on the merits. Meanwhile, prior to that date, there's a discussion in July in a conference. The Judge Burak makes it clear that he thinks the documents are going to show that, oh, everybody knew that the payment was due at a different date.
Specifically, documents.
And Mr. Smith says, he says, I have no idea what the documents are going to show.
Specifically, we're looking at document 7474, right?
Right, and that says absolutely nothing about the timing of the document. And it is unquestionably privileged, and this court ruled the last time, and two members of this panel were on that panel, they ruled that that document was privileged and it was directed to be produced solely because of this theory of at-issue waiver that would revolutionize the law.
And I think this court, at that point, in that decision, did not address the other issues that would have prevented it from being disclosed.
It expressly did not.
Right.
But this court agreed
with the at
that
issue
it
was not
right
on the table.
And by the way, Friedman Kaplan sanctioned by Supreme Court for even arguing to this court that 7474 was produced only on an
Let me ask you this question that kind of caught my eye. There was also an appeal by Mr. Ashkenazi with respect to the second summary judgment motion that the plaintiff prevailed on, the one that, that was recent with the sanctions motion, right?
Yes,
Right,
and that was withdrawn.
He stipulated to withdraw that. I thought to myself, that withdrawal really puts you in a bind, because if you were to prevail on that on appeal, wouldn't have that vindicated you with respect to the sanctions motion?
Well, Friedman Kaplan does what's in the interest of his client.
No question, but I'm thinking out loud, and that's why it does provide you with some sort of...
True, we definitely would have been in a better position here, but we don't need to be in that position to know that we prevail in this case, because every finding of misconduct is demonstrably wrong. I just started with one of them, 4747. We weren't obliged to accept. This court ruled that we were correct. Sanctioned for a false argument, a misleading argument. Nothing false or misleading. This court knew at the time of that argument that Justice Burak had issued a new order that purported to say that the order appealed from said something completely different, that it was produced on other grounds. It didn't say that. It cannot fairly and reasonably be read to say that. My client wasn't bound by that statement and order. It didn't have to come up to this court, which knew all about it. It knew all about that order. It wasn't before the court, but it knew all about it. My client wasn't bound to come in here and say, oh, we throw up our cards. This court didn't have to reach it, but it did. Maybe it reached it because it was important to set the law straight so you didn't have this wild, as this court almost used it, close to what it said. The theory articulated by by my adversary and not issue a waiver is it's indefensible, right? And so we didn't have to, nothing else we had to do on that. The court says in the sanctions order, the court says, oh, well, one of the reasons was because, well, in the sanctions order, as you should have known, and drops a footnote on a portion of its quoting back from the October 12 order appealed from that cuts completely against the court. It firmly supports the proposition that it was produced only on that, and drops a footnote and says, oh, that was a mistake.
Okay. Thank you.
Okay, well...
You have rebuttal time. Thank you.
No, I had a number of points, but hopefully on rebuttal I can make, because there are many other grounds that I've not had an opportunity to address.
This is such an important, if it's okay with the bench, we'll give you a few more minutes. That's fine. This is really important. So,
Justices of the Appellate Division, good afternoon. Stephen Meister for the respondent. I'd like to direct respectfully the court's attention to one single page of the 256-page record, and that is page 817. Page 817 of the record is a privilege log. Now, it's a little difficult to read in the paper record because the log got shrunk.
But counsel, the way I read, and correct me if I'm wrong, it all boils down, it seems to me the Supreme Court took issue with Mr. Ashkenazi's sort of moving around. He takes one position, then he takes another position, and the law firm perpetrating, or at least pushing that position.
I don't think that's a fair characterization, Justice Owing. And this is why I'm directing the court's attention to 817. What the court took issue with respect to the summary judgment motion, yes, what you said to Mr. Ashkenazi's flipping. But with respect to the sanctions, in this privilege log, okay, with respect to one of the emails in question, the lawyers at Friedman Kaplan wrote, regarding Ben Ashkenazi's potential liability of $20 million at the 5-year paydown date. At the 5-year paydown date. Now, what that means is that a lawyer at the appellant said that this email in question regarded Mr. Ashkenazi's liability at the 5-year paydown date. Now, even though, and that privilege log was produced on September 27th of 2022. Nevertheless, on December 23rd of 2022, the appellant law firm submitted a brief below that said that the emails do not address the timing at all in the face of the teeth of that privilege log. And in addition, they said in Ms.
Well, there had to be other reasons for them taking that. In the face of that privilege log, lawyers will make arguments, right, for other reasons that would support their contention, correct?
The lawyer wrote the privilege log.
Right.
The privilege log directly contradicts the statements made by the court in September and October that no documents existed related to the timing question. So what happened is that the judge, Justice Barak, found those statements about there not being documents related to the timing either disingenuous or mendacious. Now, and that privilege log directly supports the judge's conclusion on that. Now, you just heard, here's a separate item.
Was that before or after we reversed on the fraud finding that Supreme Court made? In terms of what you just, in terms of the timing?
This is all before the...
with the first department
right.
issues his
So
decision.
But
everything ties to that fraud finding that the Supreme Court made, correct?
Well, this privilege log relates to the mendacity of these statements by the appellant.
I don't disagree with that, but in the sense that that was that provided the seat for Supreme Court to say, or at least assert, that there was a fraud here that was committed upon the court, right?
I think that's
guys
probably,
made the argument.
I think that's
right?
certainly a main factor
Right.
in that.
And then well, not me, but the court here reversed that finding, saying no.
That's right.
So then it has to be what happens afterwards.
No, because the fact that there was a reversal of a fraud finding is not the same as reversing a finding for sanctions, because it has to go to undermine the integrity of the proceedings. That's what this court said. You don't have to undermine the integrity of the proceedings for a sanctions finding. So respectfully, I don't agree with your statement. I now want to talk about the statements that counsel has just made and made in his brief, which I think are improper and unfair characterizations of the record and what Justice Barak did, that he made up a new support for his admission of these documents besides the at-issue waiver in his re-argument order. If you look, there are at least 4 pages of the record, Record 112, Record 810, Record 122, and Record 134. These are all documents from October, November of 2022, before the second decision of this court in this matter, reversing the fraud finding. In in document or page 112, which was an order on motion, Justice Barak wrote, these communications are not necessarily privileged for at least two reasons. First, the communications may relate to business issues and not legal advice. And then the second was potentially the ad issue waiver. At page 810, which was a November 28, 2022 email chain, the court wrote with counsel, I refer both the plaintiff and defendants to the order indicating that the privilege is waived or that these communications might not otherwise involve legal advice and thus may not be privileged. At page 122 of the record, which is a transcript on October 13th, 2022, concerning these privilege issues, or I shouldn't say privilege issues.
The way I hear the argument, it's a continuation of the ad issue. That ad issue keeps going. It takes on a life of its own.
I am saying that I was there. I know that Justice Barak was clear that he was considering admitting emails on three grounds. Some of them on all three, some of them on one of the three, some of them on two of the three. One was ad issue waiver, one was lack of privileged content, and the third was CCing people who would break the privilege. That was all known. Now,
okay, you know what? We got it. Thank you. I want to give time now. Thank you.
What some lawyer may have said about one particular document and hundreds of documents of privilege law is inconsequential. None of these arguments were made. None of these arguments were made before for Justice Barak in support of sanctions. That's number one. Number two, this fraud the notion of fraud on the court. That the court found that he made an improper finding of fraud on the court, and that we got sanctioned for having made that argument. That's incredible.
That's why I mentioned at the very end, it's a continuation of the same fact patterns now that forms the basis for this sanction against your firm, correct?
Right.
It's nothing different. It's nothing new it's not a new thing or a new fact that occurred after our decision.
We argued correctly that there was an improper finding of fraud on the court. This court agreed, and then we were sanctioned for making an argument in this court. Why this court can't take care of that is another matter entirely. But that we were sanctioned for an argument that this court correctly made, and if he could do that, sanction lawyers for what trial, for what happens, what in appellate courts, boy, that has a big chilling effect on appellate advocacy. Now, on that document 47.
Let me ask you a question. This case was commenced when? 2020, right? It got resolved. It's pretty much over now, right? Because your client, Mr. Ashkenazi, paid the $20 million and so forth. So it's like 2023, 3 years. That sounds like a big delay. Is that's a delay? I mean, I get the sense that there was the argument was delay.
Well, I don't think so either. I mean, look, but the big picture point is Friedman Kaplan comes into this case basically in Supreme Court in basically July, and all of us, and it's previously been a case purely about the law. And it doesn't know. There's no reason for it to think that it knew about the extrinsic testimony that Chris and Ashkenazi could give. There was no reason for them to bring it up, even if they did. There was no obligation for them to bring up this that evidence. None whatsoever. They could have brought it up potentially at the attachment motion. That's the first thing that came up.
I didn't get the
bring
sense
it up on the motion to compel, because that was the motion to compel privileged documents.
I didn't get the sense in this record that Friedman Kaplan made a ton of motions to delay this case.
They didn't make any motions.
I mean, maybe a couple here and there, but
here's what happened in this case. Here's what happened. Friedman Kaplan steps into this case late in the day, more than 2 years after it's been going on, after acting as appellate counsel. Within 3 months, it's falsely and improperly accused of fraud on the court. This court found it. And what happens? What happens? They're not daunted. Sanctions are serious. Reputations are besmirched. They're sanctioned for that. And the reason the courts are careful, because they don't want to chill appellate advocacy. Friedman Kaplan appellate advocacy was not chilled.
Well, putting aside putting aside appellate advocacy, how about the trial level? What's your,
How
how about at Supreme Court? What's your take on that? In terms of, you know, I heard you argue about, look, you're chilling appellate advocacy. What happened in Supreme Court?
I haven't had a chance to address those specific findings, Your Honor. They're all in our brief, and so it's okay if I don't get a chance. All right, fine. Yeah. They're all in our brief. Not a single one of them is defensible. There was not of the citing grounds. My adversary's talking about things that just don't have anything to do with the grounds for excited, except for this crazy notion that somehow 44.
You mean 74?
Not produced
74.
I said to as many people, I always get the numbers
Want to
wrong.
get the number right.
When I was younger, I wouldn't get them wrong.
Okay.
But for 74, there's no way you can look at that document. Nobody can look at that document and say it was produced because it didn't have, all it did was convey business terms and had no legal advice. It's a selection of what counsel's views are of what the salient details. That's an attorney-client opinion. And then it gives an opinion about the significance of that. I don't want to say this. I hope not to say this.
Don't.
You cannot. Okay.
No,
all right.
don't say it. Don't say. You gave me the.
I'm
You gave me the lead. Don't say it.
I'm going to say a mild version of it. Okay. I'm going to say a mild version of it. That contention by Justice Borak that's what he really meant. That's what even though he didn't say it, and that we could be sanctioned for that when we persuaded this court that was correct. That's just indefensible. That cannot stand. You've got a firm that did its job. It acted in the highest traditions of the bar, and I stand on the briefs. There is nothing that this court can find that Friedman Kaplan did that was in any way erroneous. It was high-quality representation. It was ethical representation, and it was in the best traditions of the bar. And now they're sanctioned. 4 lawyers with extraordinary reputations. 4 lawyers, 2 young lawyers and 2 more senior lawyers. And Mr. Meister stands up and argues in his brief something that was never found by Justice Borak, that they suborned perjury, they invented the testimony. He's accusing of criminal conduct, and that's how he's asking you to uphold these sanctions. It's a disgrace.
Thank you.
Your Honor should vacate, and Your Honor should not simply say they were improvident. Your Honor should say that Friedman Kaplan committed no misconduct. That's the only fair thing that can happen.
Thank you, counsel. Minash versus NY Institute of Technology.
Your Honor, I'm here for a reversal on the motion at the Supreme Court. And I was a former student of New York Institute of Technology since from 2002 to 2003. After 2003, I ran out of funds because I came from Africa and to study over here, so I ran out of funds. And when we were in school, before I was getting admitted, they told me that when you run out, you could be a student after some time, but if you run out of funds, you could take classes, and then the school hold the grades for you for some certain time until they release it for you if you have the money to pay. So in 2005, I went over there to see the international student, Dean of International Students, to have the grades released for me so that I could work as a normal student who has graduated out of the school to work. But actually, I was arrested and put under trespass with the school, and which was unfair to me because when I was being admitted, I came on contract with them to pay for school and to graduate and stuff like that. But I was arrested, and it was being unfair to me. So I wanted the court to reverse the motions for default of judgment and also the motion on New York Institute of Technology to dismiss my complaint.
Thank you.
Clifton Bud and Di Maria by Douglas Catalano and Melissa Romaine. We're sorry for any misunderstanding that the plaintiff may have about what did or did not occur, but clearly, with respect to students in a college setting, the standard is whether or not some contract was breached. At best, for plaintiff, that's the only possible claim he could make here. Some 20, or I think he said that he resurrected his claim in approximately 2009. So if there were a breach of contract case that he's now asserting, it's a long time barred, even if we could ascertain the specifics of what Mr. Mensah is claiming. But at most, it appears to be a breach of contract claim, and it's long time barred. And of course, the facts set forth by him are not cognizable for breach of contract. Indeed, he's apparently admitting that, according to him, he was allowed to sit in various classes and pay at a later date, some 11 classes or so. I don't know whether that's accurate. This is 20 years ago. But if it is, then that's a breach of contract claim, if it were to be true, which we do not believe to be accurate. But we're sorry for his misunderstanding. And he's a pro se plaintiff, so.
Thank you.
Thank you.
Okay, thank you. Thank you. You didn't ask for rebuttal time, so we're done. Okay.
I wanted to say, in 2005, I went over there to pay for the fees, and they arrested me, put me under trespass, which is unfair to me.
Sir, maybe it might be worth your while. I mean, you're all here if you want. I don't want to tell you what to do, but everybody's here, so, but thank you. Thank you. 5th and 55th versus Vistiana signature.
Good afternoon. May it please the court. Chris Langone of the Bar of Illinois, pro hoc vice, on behalf of the 5th and 55th Residents Association. This case is about a residents association that hired a manager. The manager breached its fiduciary duties to the association in conjunction with a rental program that was being run for the benefit of the members. Some of those members filed a case in federal court. That's called the Gillespie case. That case was originally filed as a Jennifer Realty claim on the grounds that not enough units were sold in the fractional interest association to make for a viable common interest association. During the course of discovery in that federal case, it was discovered that the manager was taking kickbacks from the hotel in the amount of $2.1 million per year to basically not rent any of the units to the members, but to keep them on reserve for the hotel so that the hotel could basically have overflow occupancy to inflate its rental rates for a sale. The trial court erred in holding that the 5th and 55th Residents Association's claims were essentially a repackaging of Gillespie, right? And that's what respondent says in their brief, that this is just a repackaging of Gillespie. They lead with a collateral estoppel argument, which we think is essentially the weakest argument, because there is no identity of issues, there is no identity of parties, and the association was not given a full and fair opportunity to litigate its claims in the federal court. The claims that were litigated, that were attempted to be litigated in the federal court by the Gillespie plaintiffs, were unjust enrichment claims. Why were they unjust enrichment? Quasi-contractual claims? Because the Gillespie plaintiffs were trying to shoehorn something into non-contractual relationships into a claim at the last minute when their Jennifer Realty claims were going down the drain because the manager didn't owe any duties to the members. The manager owes duties to the association, the plaintiff in the case below. So contrary to what the respondent says in its brief, This is not a case about the members' rights to the rental program. It's a case about the manager's responsibilities to the association, both as a fiduciary.
But I thought the agreement provides that the manager is responsible for check-in, check-out services, cleaning and linen services for each club unit as necessary and any other club operational matters, assuming there is no privity with the Gillespie plaintiffs, where am I reading? Am I reading something wrong here in terms of what the manager's responsibilities are under the agreement that you have here?
Well, on page 291 of the record, it's section 6, it says the club manager's duty is shall deal at arm's length with all third parties and shall serve the club association's interest at all times. So to the extent the club association has a duty to run the rental program and it hires the manager to do that.
That's to the extent they have a duty to run the rental program. Where in the
Correct.
agreement do they run the rental program?
I'm sorry, could you
You
repeat
just
that?
said that if they have a duty to run the rental program, where in the agreement do they have that obligation or authority to run the rental program?
The association, well, the rental program was made part of the benefits as part of the.
No question, but in terms of the manager, do they have the authority to run the rental program?
The association hired them to run the rental program, correct. The association could have hired its own employees to run the rental program, but it's part of the manager's duties to run that rental program on behalf of the association, and then the association owes its own fiduciary duties to members.
Isn't there something, I'm not sure if it's in the offering plan or if there's another agreement, whereby if you choose to use the club manager to run the rental program, then you're on notice that if you do, somehow the hotel's units would take priority over any other rental of any other units, including the association's units.
Members are told that if they put their fractional interest into the rental program, that they would be competing with the hotel for rental of nights.
Right.
Nobody was ever told that the hotel had basically bribed the manager to rent no nights to the members at all, to basically keep them on reserve for overflow. So it's an issue of both quantity versus priority. And I'll reserve my remaining time for rebuttal.
Thank you.
May it please the court, excuse me, Chris LaRocco, Brian Cave, Leighton Paisner here for the respondent. As I believe the court correctly suggested at the outset, by hiring manager in that act alone, plaintiff is claiming that therefore secures greater rights for their members than their members were granted pursuant to their purchase contracts.
Your guy's an independent contractor.
Correct.
Right? You're hired to do something.
That's right. And I will say along those lines, we were not hired to run this rental program. The offering plan makes it very clear that the rental program is not part of what people buy into. It is an optional extra contractual benefit that was devised by the sponsor of the club, and it is the sponsor of the club who tasks the manager to administer that. And that administration of that program is governed by contracts between the manager and individual members. There is no relationship, that management agreement.
You're the go-between. You're just here's the rental form, but we're not. I mean, we'll just give it to you for you to fill out.
Well, right. And technically, what happens is they'll sign the rental agreement, which again sets forth a priority, saying, "Look, your rooms are going to be rented last."
Right.
And then what we do is submit that to the hotel, and then that time that's submitted goes into the hotel reservation program, and then at the again, and if the hotel rooms are sold out, and then if any other inventory is sold out, then you can go to the members and rent that room.
So it's fair to say that plaintiff was responsible for the reservation system and the manager was responsible for the rental program?
No, the reservation system is run by the hotel, which is not a party to this case and has never been a party to the case.
And the only thing that the club manager would do is let the hotel know that these units would be available for rental?
Correct. They are in essence, a go-between. Again, they sign an agreement with the individual members that sets forth the terms and conditions of this program vis-a-vis the members, and then they provide that inventory to the hotel, which can be rented at.
And then the hotel makes the reservations.
Correct.
They are the ones that administer that. Now, the association or the members have the option of doing it themselves instead of going
Correct.
through the manager.
This is not the only way by which members can rent out time in their interest. They can go to Airbnb, they can rent to their friends. I mean, there's all sorts, whatever means you might think, they are not restricted to only using this program. It is a voluntary, extra contractual benefit that is being offered.
You didn't think that you were being hired as an independent contractor will all of a sudden elevate you to having fiduciary responsibility.
Well, correct. I mean, that is a separate issue in the sense that not only do I not believe that was the intent, but that, again, the complaint, the second amended complaint here, which is the 8th pleading that this entity has filed, doesn't set forth any facts that would suggest that there's a fiduciary relationship there with respect to the rental program. Again, a manager of a hotel, or rather this residence club, which runs like a hotel, has certain responsibilities that are enumerated in that contract. The rental program is not one of them. And again, this idea that they were hired to run the rental program is also false in the sense that, well, again, the agreement,
agreement speaks for itself, right?
Indeed, Your Honor. And just to back up this point with respect to collateral estoppel, this is indeed the same claim that those Gillespie plaintiffs claim. They said, hey, it's unjust, the sponsor, is what they said, was unjustly enriched because they're being able to rent their hotel rooms their rooms, the unsold inventory, to the hotel above us, to the members. Here, you just have one layer. Now those members, which are the sole members of the plaintiff here, right? It's an entity that comprised entirely of members with the specific purpose to benefit those members, is now saying, well, actually, it's not industrial enrichment, it's a fiduciary duty that you have to treat everybody on a pari passu basis in this rental program, which again is the same claim that those folks made and was denied by the Southern District of New York in a very well-reasoned opinion that looked at the same documents that are at issue here. And to the extent that we're saying that the plaintiff is now claiming that somehow these kickbacks or whatever make it different, I mean, it's not. The idea of the kickback, which really was just the rent that the hotel paid to its affiliate, the hotel paid to the sponsor to cover the depreciation of the unsold interest, which again, affiliated entities that were owned by the same, I'm not sure why they would need to bribe one another. But in any event, that was a payment that they claim enabled this non-parity situation. Again, it's just another layer of the same exact argument. And so I would argue that collateral estoppel does apply here. In any event, the fiduciary duty claim is without merit. Thank you, Your Honor.
As we argued throughout our briefs, we're getting mired in factual disputes that were improperly raised on a motion to dismiss. We allege in our complaint that the manager had a duty, among other things, to run a rental program. It wasn't like the manager was hired just to run a rental program. This was a common interest association, just like a condo association, and like many condo associations that hire managers to do the budgets and the financing and run club events and do everything that you do on behalf of the condo association. And just like any manager on behalf of a condo association, it owed that association fiduciary duties, including a duty of loyalty. And that duty of loyalty would have entailed telling the association, oh, by the way, our sponsor, who basically is us, is getting, we're getting $2.1 million from the hotel to basically not tell anybody that nobody's ever going to get any rooms under this so-called rental program that you think we're running, but that nobody's ever running. We should have been able to get past the motion to dismiss, to flesh these out on a factual basis, but the trial court erred and got confused by thinking this was simply a repackaging of derivative Gillespie claims. Whether this was, yes, we had tried to allege some antitrust claims and other claims. We had filed in federal court and it got sent back here on a venue claim. This isn't the 8th pleading because of pleading attempts. We tried to be in the federal court with Gillespie on a related basis, and it got sent down on a venue claim. The same venue claim that said our antitrust claims had to go to Florida. But this fiduciary duty claim never got a hearing on the factual merits. And we should be entitled to prove up our facts. We allege those facts. This manager breached its duty. It accepted bribes and kickbacks. Collateral estoppel is an affirmative defense. And we believe that the case should be reversed, and we should have the opportunity to prove up what we alleged. Thank you very much.
Thank you.